Good morning. Dilen, are you there?
Morning, everyone. I am here. Present.
Good. Okay, so yeah, to everyone who's logged in so far, good morning. Thank you for joining our webinar, Taking the Fees Out of Attorneys. Just to quickly get started, I'm going to introduce our panelists, Willie Roos and Dilen Heerschop. So Willie Roos, for those who don't know him yet, Willie's practiced as a property attorney for over 20 years. He was involved in sectional title management for over 8 years, where he dealt with various municipal bills and interacted extensively with local municipalities. Willie started Stratafin in 2014 with the goal of assisting body corporates with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. Dilen Heerschop. Dilen is a practitioner of the High Court, specializing in law pertaining to community schemes and the concomitant compliance issues faced by community schemes. He's conducted various seminars for the National Association of Managing Agents on compliance aspects relating to the Property Practitioners Act. Dilen obtained his LLB degree with distinction and therefore completed his LLM in estate law thereafter. Dilen has joined DTB Attorneys as a community scheme specialist attorney. DTB Attorneys is a Stratafin preferred service provider and panel attorney. If you don't mind, we're going to do a quick poll of 3 questions. I'm just going to do them one after each other. It'll only take a minute, and yes, and then we'll continue.
So the question is, what is your main function? Are you a trustee, a managing agent, a portfolio manager, an owner, or other? And on the others, let's make them attorneys. So let's see how many other attorneys are on here, Dilen. How many of your colleagues are sitting here with us today?
Yeah.
All right, guys, are all finished? Lauren, just give it 10 seconds so that people can just finish and then show us the results on there.
Super.
So the others, are they attorneys? We don't know yet. We don't know, but it seems there are a couple.
All right, I'll do the next question. Okay, our next question is budgeting for legal fees. Has your scheme budgeted for expenses in respect of legal collections, and does it form part of your levy? I'm going to end the poll and share.
Sure, quite a bit, 45%, hey? They did not budget.
Okay, and then just the last question, we'll just take a second. Apologies. Okay, legal fee expenditure. How much are you paying for collection matters from summons to sale and execution? Super, thank you. There are the results.
Lauren, just hold open for a bit there.
Sorry. Would you like me to relaunch? No, Chanel.
No, that's fine. I just want to see this. I mean, we're saying 68% is between 0 and 30,000. So 68%. All right.
Okay. Thank you. And Dilen, I'll leave it over to you.
Thank you very much, Lauren. Firstly, thank you, Stratafin. Thank you, Willie, for having me on this webinar. It's always amazing to share some thoughts, and I think this is a extremely informative platform where we can assist a lot of role players in the community scheme industry with various questions. And I think this is quite a burning topic, to be honest, taking the fees out of attorneys. I must say, just looking at the topic, it's such a profound statement. Lauren, if you can go to the next slide.
Are you there? Thank you.
Maybe load shedding. All right. So I think this is a good starting point to contextualize a relationship between community schemes and the attorneys. I don't want your love, honey. I want your money. I think a lot of attorneys think that is the way that one creates a relationship with individuals, and it's quite a predicament that some individuals face themselves after endeavoring these types of collection things. And just a few thoughts from my side. Attorneys seldomly have reasonable prices in respect of community scheme collections. And these red flags that I've come to see in the industry is, firstly, some attorneys only charge hourly rates for collection work. This, to my mind, enables attorneys to exaggerate time spent on simple tasks. A lot of attorneys may let everyone think that your specific matter is so special or so one of a kind that they don't make use of templates or something of that nature, and then they try and sell this hourly rate to you. To my mind, any collection matter should, in extreme circumstances, only warrant the hourly rate, and in general, collections should be done on more of a type of fee structure, if I can call it that. The second thing that I've seen that attorneys like to do is extreme itemized billing structures. So, for example, as a managing agent, one would inquire what is the progress on my matter, and then in terms of this extreme itemized billing structure, they start billing you for each and everything. I mean, to my mind, it's similar to a Vodacom or whatever contract. The moment one agrees to these types of itemized billing, it's all good and well. The first month you start phoning and using data and YouTubing, whatever, and then at the end of the month you get this exorbitant bill. So this is another financial red flag to my mind. And then the last thing that I would just want to touch on this slide is the difference and the disparity between attorney and client fees and party fees. I always equate this difference to that of a medical aid or type of situation. I mean, when we all have medical aid, the lucky ones, and when we have these medical aid, they say, yeah, they cover us for 100% of whatever the medical bill might be. But then at the end of the day, these medical aid tariffs are so low that there is this disparity between what the doctors charge and what the medical aid actually covers. And that is the clear difference between attorney and client and party. Attorney and client is what an attorney conventionally would charge in his fee structure, whereas party is what the courts prescribe or suggest the tariffs to be. And it's important, and we'll get to this disparity and how it actually affects a community scheme on the next few slides. So to my mind, the best would be that one should have nifty tips and tricks when appointing an attorney. When I did my own preparation for this meeting, I just Googled the word Venn diagram, which gave me a lot of nightmares when I still had maths in school. So it brought back some sobering memories from school. But one can always look at a relationship between an attorney and a client in this Venn diagram. So part A of the Venn diagram on the first circle would be the time. So how long does one wait for one's matter to progress? B would be the money. How much will it cost me, or how little will it cost me for the collection to occur? And C would be expertise. And the unfortunate reality with any collection matter is that one cannot always have everything. So for example, if you want your collection to be done very speedily and you want a highly experienced attorneys, the money component of the Venn diagram is going to be high and it's going to cost you a lot. If you want something to happen very fast and you want to cut a few corners financially, or you want it to happen on a very cost-efficient basis, the experience or the quality of work that you are going to receive is lacking. And similarly, if you want to save money and you want to use an experienced attorney, the time that the attorney is going to take to actually now undertake this collection endeavor is going to lack. And that is the problem that we're facing. I mean, we can see in the Venn diagram that there is a part in the middle where all three of them overlap. We call this the unicorn. So if any of you find this unicorn, please inform us so that we can appoint these attorneys and employ them. But these are cost-efficient attorneys that don't take a lot of time, but the quality of work is also high. So ultimately, we need to understand that this is the problem. We may have an attorney that is willing to help us. They've got the necessary expertise, but we are not willing to pay them. Then we're going to look at a situation where your matter might not be his highest priority, his or her highest priority, and that is where it will lack. Or we may have a situation where we've got an attorney that's willing to do it at light speed. They're willing to do it extremely cheap, but then one again looks at the situation where the expertise and the quality of the product that this attorney will deliver is going to be lacking. So it's important to consider this. I've also prepared actual tips and tricks. I think this is just a very informative display as to the in respect of an attorney and a client's relationship. So on the next slide, you'll see that I've included a few tips and tricks. The first thing that I would suggest if I was a managing agent or a body corporate or even an owner in your own private collection matter that doesn't even relate to community schemes, the first thing to my mind would be that one asks for an acceptable fee structure. And I mean, the unfortunate reality is all attorneys charge differently. So one would just have to find an attorney that charges on an acceptable fee structure or something that's acceptable towards the community scheme. Another aspect for me that is very important is the transparency or the flow of information between the attorney and his client. So to my mind, I would say that there should be monthly progress reporting at the very least, and in shorter intervals could also be good. It just depends on the particular circumstances of the matter. And then also just touching on this progress reporting issue, a lot of attorneys like to include a lot of legal jargon. It sounds very fancy when one reads the progress report, but ultimately, before and after reading the progress report, one has no idea where the matter has progressed. So to my mind, insist on a legal progress report that makes sense, that is understandable to you, because ultimately, at the end of the year or at the end of the day, one would have to be tasked with reporting back to your owners or reporting back to your trustees if you are a managing agent. And in those circumstances, it is important for us to know that we understand the progress report and that we on a frequent basis receive these types of progress reports. Then I think it's one of the most important ones, expertise in the law pertaining to community schemes. Now, I think attorneys are very good at cashing checks with their mouths that they can't cash in practice or selling themselves as a product. But to my mind, it's always important that they have expertise in the law pertaining to community schemes. I mean, there's a saying, jack of all trades, master of none. And I think that is really pertinent, especially in community scheme collections and community scheme law, as it is extremely specialized. So a jack of all trades, although they would say, listen, I'm capable of doing this, the quality of the work, and that's the situation that one would be faced with, is that if one does not know whether or not this particular attorney is an expert, where one would have a situation where the product that one gets might not be favorable and the outcomes in the collection endeavors might not be favorable. So it's important that we actually make sure that they are experts. And I mean, it's easy to ascertain. start asking them questions about community scheme law. I've got a decision, or we as trustees have a decision to make. What type of decisions should you make? And I mean, off the bat, attorneys with expertise would know these types of intricacies and nuances in community scheme law. And the moment that one is comfortable, then I think it's a good idea to start using those attorneys that actually has expertise. Another one.
Dilen, sorry, can I
Yes.
just jump in here? I mean, we frequently in Stratafin get a question from schemes where they've been in the legal process for years. And then they tell us that the property is bonded and that property can't be sold because there's a bond over it and the bank does not want to agree to the sale in execution. Now, you and I both know that that is no hindrance to a sale in execution. The other one that we frequently find as well is that it's an estate late and the estate has not been reported. The attorney says there's nothing that they can do at this stage because there is no estate, so they don't know who to sue. Or alternatively, there was an executor appointed, but they can't do anything further than that because there's an executor now. So, I mean, we see those things on a daily basis where we assist schemes with financing, and these are questions that come up the whole time, and where attorneys are used and attorneys are saying that they are experts in community schemes law, but they can't even get to the point of a sale in execution of a bonded property.
Yeah, and again, another example is primary residence of a property. We can't sell it because it's someone's primary residence. But again, ultimately, that is why, and as Willie actually now reiterated, that is why it's important that the choice of attorneys is probably the most important factor. I mean, cost and time is also definitely a factor that influence the decision, but I think it's important at the very least that we know that we're dealing with someone who knows what they're doing. I mean, practically speaking, if you want to do IT type of stuff, and I mean, I don't portray to be any expert in IT, one would not come to me and ask me about the IT issues. When you have a leaky roof, you would not ask an attorney to help you. You would find a plumber, and that's exactly the thing. So make sure that your choice of attorney is extremely important. The next thing is affordable accessibility to an attorney. So one gets, in my mind, 3 types of attorneys. The first one, an accessible attorney, but an expensive one. So he'll always answer your calls. He'll always reply to your emails, but he is very expensive. Just go back, Lauren. It's a bit quick. Thank you. So that is the first one. And I mean, we don't want that. We don't want an attorney that is willing to assist, but you are going to pay an arm and a leg for simple accessibility issues. The second one is the ghost. You would know things happen because you get a bill, but other than that, you hear nothing from them. And that is also a problem. I mean, as the custodians, if I can call it that, of the community scheme, the trustees and the managing agents are almost expected by the owners to know what's going on in the collection matters, and an attorney that is not accessible at all would not help in those endeavors. And I mean, this would lead to situations where the schemes or the owners of the scheme might get frustrated with the trustees, and this would in no way benefit the collection process or the general management of bodies corporate. And then the last type of attorney is an attorney that's accessible and affordable. Again, I would say a unicorn in the industry. You don't find too many accessible and affordable attorneys, but it's important that if one has to pick up the phone and phone someone, that you either get an answer or that they come back to you. Because I see in the industry, there's a lot of attorneys, and I mean, I work with these colleagues where they're opponents of mine, and then I, as an attorney, struggle to get a hold of them. So it's important that we have attorneys that are actually accessible to us. And then the last thing, willingness to provide general or other assistance. I think it's important as an attorney, you can't just work within the 4 confines of collections and say, do you know what, any other problem that you may have, go and find someone else, or whatever the case may be. You need a relationship with an attorney that when one emails them and say, listen, I've been thinking about this, or this has happened now, what happens, what can we do, that there's an attorney that is willing to assist you with your general community scheme related issues as well. Because I mean, ultimately, yes, collections are very important, and it forms the backbone of the finances of a body corporate. But general issues like someone's busy building and they've not got an approval or something like that, it's important that those things are also dealt with. And then one needs an attorney that does not only focus on collections, but also in a position to provide this general or other advice. All right, and now I've alluded to it. I've said that there's this disparity between between party and party costs and attorney-client costs. And the issue comes in with prescribed management rule 25.4. Lauren, just on the next slide, please. All right, so there's quite a predicament. I think a lot of us have heard about prescribed management rule 25.4. Some of us may know what it says, but after this, everyone is going to know. So prescribed management rule 25.4 says that an owner is only liable for legal fees as taxed or agreed. That is the gist of it. And ultimately, what we need to understand, I've never seen an owner who has agreed to the fees. So ultimately, the yardstick is going to be taxed. I mean, practically speaking, if someone phones me and says, listen, I'm going to sue you now, but I want you to agree to be liable for those fees, I don't think in a practical or sensible world, anyone would say, yes, I'm happy with that. Please charge me the higher amounts or whatever the case may be. So this is where the predicament comes in. I've said that party is what the courts prescribe, what they say the amount of fees are, and what we are entitled to when we do these collections. But this differs from what an attorney may offer in respect of his services. And the problem that we're faced with is who is going to pay the difference? That's the ultimate answer. So we're entitled to include taxed fees on their statement, or they're liable for those fees, but the difference needs to be carried by the body corporate. So what are these implications? What implications may it have? Firstly, we've asked at the start whether or not one budgeted for legal fees. I saw, if I'm not mistaken, 45% of the answers were no, which means that an administrative budget does not consider legal fees. But what does that mean? I mean, when one looks at specifically body corporates, but I mean, this equates to HOAs as well, trustees are only entitled to expend funds in accordance with their approved budget. So now we've not budgeted for these legal fees, but we're paying legal fees. And that's a problem. I mean, ultimately, when the owners were tasked with saying, accept this budget, they did not know that you decided or wanted to use an exorbitant amount of those funds for legal fees. And then again, this also relates to a cash flow issue. So now we've got an electricity bill and we've got an attorney's bill, but we haven't budgeted for the attorney's bill. So now we've got a deficit in our budget, if I can call it that. And ultimately, and on the extreme end of the equation, one may be in an instance where there's serious cash flow issues, or even the inability to pay other expenses because of the fact that we didn't budget for legal fees and we actually had to pay it. So that is important to note, that there is a predicament in this, and that we need to understand that firstly, we need to budget, and secondly, that we need to make sure that our cash flow accommodates the legal collections. I'm of the view that some attorneys may be the cause of schemes' financial difficulties. I mean, the amounts of money that I've seen being paid to attorneys in respect of collection matters are shocking, to be honest. And in those circumstances, I mean, if one has 10, 15, 20 collection matters, a lot of money is going to flow from body corporate, and it may result in this financial pickle. So yeah, it's important that we just know this predicament. Willie, anything to add?
Yeah, there was a couple of questions that I think one can touch on again. I mean, we've touched on them as examples of attorneys that are saying that you can't progress with a matter because it's a bonded matter or a bonded property. So that was one of the questions. We need to elaborate a bit more. Specifically, I mean, a bondholder is a preferred creditor. So at a sale in execution, all amounts paid that is less than the amount of the bond will go to the bondholder as the preferred creditor. Any payment over and above the payment of the bond will then go to the creditor that instituted the action and that has the warrant and that has arranged the sale in execution. So the bondholder is protected to the tune of its bond or its outstanding bond. So in general, what we see in the industry is that the bond plus the levies would exceed the value of the property, and you would not be able then to sell your property because nobody's going to be wanting to purchase the property at a sale in execution where the bond needs to be settled because that is the COB or certificate of balance. And the levies has to be paid and rates and taxes has to be paid by the purchaser because that's what your conditions of sale normally says. So that then means that that sale stops at that moment. But that is not the end of the matter. So one can then apply for a reduced amount. So one goes back to court, apply for a reduced amount in respect of the bond. So the court will then reduce it. So one will have to explain exactly why it is required that a lesser amount be accepted in terms of the bond. And the bondholder at that moment then starts to be responsible for protecting its own bond. So if they want to protect their bond, they will have to go and bid at the auction. And if they then buy the property in to protect their bond and to protect their value, they will be liable for the payment of the levies at the end of the day. If that sale in execution, say for example, the bond was reduced from R1 million to 500,000 Rand, and still we don't get a sale, then you can apply again for a reduction of that amount. And at the end of the day, the court will say the bondholder must come and protect its own right at the sale in execution. So you will get a zero amount COB, or not a zero amount COB, but a reserve price, a zero reserve price, and the bondholder will have to protect its own right. So if they don't, then whatever is attained at that sale in execution goes to the bondholder. So say the property was then sold for 100,000, that goes to the bondholder, but the purchaser then has to pay the outstanding levies and rates and taxes. Have I got it right, Dilen?
Yes, you have. And I mean, this is especially prevalent where, let's say, for example, the property is worth R1 million, the bond is 800,000, the levy is 400,000, and rates and taxes is 200,000. So now we're sitting on this exorbitant amount, which is actually higher than the market value of the property. And I mean, no sensible investor is going to say, yes, I understand the property is worth R1 million, but I'm willing to pay more. So, and in those instances, it's almost clear cut that this reserve price be reduced. And as Willie indicated, so you go to court, say, this is the facts, this is the situation. We can't sell this property. We can't allow this property to stay indebted perpetually, because that would be the consequence if we just leave it, is that thing is going to escalate so high that no one is going to be willing to pay it. And that is why the court then comes to assistance. But I think the point comes back to making sure that you've got the right attorneys. Some attorneys may say, we're dead in the water, we can't do anything for you. So that's important that we deal with these types of aspects when we appoint an attorney. I see Phil also, just to answer some questions, I see Phil said also the matter of primary residence in this matter. So why is this important? We need to understand that everyone has the right to housing, and that is the constitutional right that we're fighting against. I'm calling it fighting against in inverted commas, because it's not really fighting against, but ultimately one needs to understand that the principles in relation to a primary residence is that the court will have to set a reserve price to ensure that the indebtedness, when this owner is now, I won't call it expropriated, but when the property is now sold in execution, that the owner walks away debt-free. That's basically the principle, and that the owner will actually have an alternative residence. But I mean, this is not an end in itself. As a owner, you can't say, I don't have anywhere else to go, so you have to stay with me, or you have to I'm going to stay here indefinitely. There is still remedies. It's just important that when one has a primary residence, we need to ensure that there's additional things that we address in these types of applications to ensure that the court is actually satisfied with the fact that we can sell that property in execution. Is there a database where we can have access to these types of attorneys? My opinion, and it's my opinion. If you go onto DTB's website, you'll see the database with all of our attorneys at DTB willing to do it. But no, unfortunately, we don't have this type of thing. I think it's important that we look at the circles in the community scheme industry when making a decision in relation to an attorney. I mean, we have NAMA. There's a lot of attorneys giving training at NAMA. We've got industry experts or industry forerunners like Stratafin. Let's inquire from them. Who are they using? These types of things, so that we can know who these expert attorneys is. And it is unfortunately difficult. I mean, under every second rock in Gauteng, one would find an attorney. So it's difficult to make sure. But I think if we do our due diligence, we start asking the attorneys the uncomfortable questions, those questions that people debate about on the sectional title living group on Facebook or something like that. If they come back with sensible answers, then it to my mind makes sense that they are experts. Ultimately, the legislation pertaining to communities is very technical, and one has to actually eat. I also always use the word eat the legislation on a daily basis. Just use it, utilize it, struggle with the legislation to become an expert, and one should just identify whether these types of individuals are experts. Who should cover the legal fees between the body corporate and the owner? As I said, prescribed management rule 25.4 says taxed or agreed. We don't have agreed. So from a tax perspective, the moment we've taxed our bill, the owner is expected to pay that. From a cash flow perspective and a budgeting perspective, the shortfall would have to be covered by the body corporate. But when we get to sale in execution, that shortfall would be recouped, because those amounts would then also be included in the clearance figure. So ultimately, yes, the owner would be expected to pay everything, but in the interim, we need to have a cash flow solution to make sure that everything is paid in the interim. So that's the situation.
Dilen, the everything that you talk about is the party and party fee. So it's not the attorney and client fee. So the other owners are actually, in terms of our current legislation, liable for the difference between the party and party and the attorney and client fee, as you explained earlier on with your example of the medical aid. So I think the question pertains to that, and that is the other owners are liable for it, because I see there is a follow-up question then regarding that and says, can't we change the rules? So in terms of the old act, the rules specifically said that an owner is liable for all the cost of collections. That it was on an attorney and client scale. So the current legislation was specifically amended because CSOS and I think government as a whole felt that there was an abuse, and people were charged exorbitant legal fees, exceeding a reasonable tariff. And that is why that was changed. And the short answer is one can try and change your rules to include all fees, but CSOS definitely will not approve it. So we have seen that they have refused that. It is one of those aspects that I think on sectional title living South Africa we are discussing, and it's one of the things that are in our list of things that we believe should be changed in respect of legislation. But there should be checks and balances, because one can also not leave that open to abuse again, because we've seen, we've seen, and you've seen that where legal action was charged to the tune of 120 and 150,000 rand for a matter, and they're not even at sale in execution. So one can't do that. That is not reasonable. So unfortunately, at this stage, as the legislation stands, you will not be able to amend your rules to include all the fees, and it's not going to be allowed at this stage.
Yeah, and just to touch on the issue of including it in your conduct rules, that is possibly a solution, but when one looks at CSOS's directives, they actually issued a directive or a guidance note on undesirable rules. And one of those things that they actually identified is saying that we are not going to register any conduct or management rules which impede on this responsibility. Ultimately, it's taxed or agreed. So if one reads 25.4, you would see that it says taxed by the member, singular. So it's not saying by the members or by a special resolution or something like that. It says by the member, which insinuates that that particular member is going to have to consent to that. And that's the problem that we're facing with conduct And management rules, it doesn't require the consent of each and every member. So that is, to my mind, the justification why this may not be the case. Okay, let's see
And
how you...
I can just also answer, a taxed fee is not a specific fee. So a taxed fee is the fee that is specifically applicable to that specific matter that is going to court. So there are various factors that are taken into consideration. So the amount that the summons is being issued for places it in a particular scale. So it can be scale A, scale B, scale C, it can be high court scale. So all those scales differ. So depending on the amount that is being claimed, it will be different scales for a summons, for a default judgment, for a warrant of execution. So all those things differ on the amount of the claim. If there are more than one defendant, then the amount will also be different, because one will be able then to claim a sheriff's fee for service on the first and a second defendant and a third defendant, whatever the situation might be. So a taxed fee is not a particular amount. It is an amount that can be justified in accordance with this tariff that is part of the Magistrates Court Act and part of the Supreme Court Act, and that a taxing master then assesses and says, okay, I'm happy. This item was reasonably necessary to do. You had to issue a warrant. I will allow a warrant. We're going to allow this amount of the warrant in respect of issuing the warrant and drafting of the warrant and serving of the warrant, because the claim amount is for 50,000 rand. So we will allow this amount. So every tax fee will be different depending on what was done in respect of your legal matter and what was and what the amount is that is claimed. So that is how it's determined. But if one does enough matters at a certain level, so we know below 50,000 or above 250,000 or whatever, you do sufficient of them, one can get to a point where you know more or less what the tax fee will be. So within a couple of thousand rand. So you will know we can tax a bill from start of issuing of summons to sale and execution of a property, where the judgment debt exceeds 50,000, we can tax for 40 or 42,000 rand. We know that because we've done so many of those, and we know that that is more or less the amount that you can recover. So you would know from experience what those amounts should or should not be. A property that is under administration, sales and execution can still take place. Normal sales can take place in a scheme that's under administration. It has no bearing, the fact that it's under administration. Administration merely is somebody else that is now in charge of the scheme instead of the owners and instead of the trustees by way of a court order. But apart from that, the scheme runs as normal. I don't know if there was anything else that you saw, but
yeah,
I think those were the things.
I think we've had this discussion too many times, but I'll ask you in any event, how effective is CSOS in terms of collections and enforcement orders in relation to attorneys handling this for bodies corporate?
So my point of view, from Stratafin's point of view, is that we do not use CSOS. They know that. I mean, I've said that to the Chief Ombud as well, in respect of collections, because we believe that the portion of collection that they do, where they do an adjudication order, is merely the start of any litigation. So once you've reached the point of that adjudication order, you in any event have to go back to court, and you now have to issue you first have to make your adjudication order of court, and then from there you need to follow all the subsequent steps. Now, in a matter where you would issue summons, and you would go up to sale and execution, and I said we're taxing them for, say, 40,000, 42,000 rand, I think you would not be able to tax the first portion up to sale and up to default judgment for 2,500. I don't think it's even worth 2,500 rand. So basically what the scheme saves is 2,500 rand out of the 42,000 rand on the party and party scale. And that's all they really save. And there are numerous risks in respect of CSOS. We are seeing that with their training in respect of the adjudicators, that the orders are becoming more consistent. But we have seen many strange orders where they apply prescription where prescription has never been asked for. I mean, you know that we do not believe that there is prescription in sectional title schemes. So they apply prescription. They would go back and say, I've heard yesterday of an order where the debtor was never asked by anybody. It was never suggested. And the adjudication order says, redetermine the amount owing, reduce your interest, and allow the debtor to pay over 6 months. Nobody's asked for it. It was a scheme that approached CSOS and say, we want an order for this is the amount of the outstanding levies. So those sort of things are weird. And from our point of view, we would rather utilize the courts because we know that there are consistent judgments. If you have done your preliminary work correctly, and as such, we believe it's better to go the court route, and it's more efficient to go that route. But that's our point of view. I mean, other people I've read on the group on Sectional Title Living South Africa have had proper collections or start of the collections process, and then they move to the courts after that. But at the end of the day, that's where you will have to go in any event. So our attitude to start there and push the matter through the courts.
Yeah, and I mean, just to touch on what Willie said, now we're getting this weird order saying that they have to repay it within 6 months or whatever the case may be. Now we're not happy with it, but they're complying with it. We've got nothing that we can do. We can't go to court now saying
or they don't comply. Or they don't comply after month one. What then? There's no acceleration clause. So it doesn't say if you've not paid the first month, now the full amount becomes due and owing. So there's no acceleration. So at the end of the day, what does the scheme do? Now I must wait a further 6 months and issue a warrant piecemeal on each little portion of the 6, or must it now obtain a new order for that little portion and then get a warrant issued on that little portion? So it's a weird, we get weird orders. I mean, we've got an order that you guys have set aside where CSOS, and that was a scheme that went to CSOS prior to us getting involved, where CSOS said that no property can be sold in execution. They don't have the authority to say that, and notwithstanding they made an order that properties can't be sold. And we had to take that decision on review. And luckily we succeeded with the review application, and the High Court agreed with us that the order can't stand as such. So yeah, so there are strange things that happen, or strange orders, but we are seeing that those orders become more consistent. I think the more CSOS listens to the industry, the more they understand that levies is the lifeblood of a scheme. And if a scheme does not have levies, then that will cause the collapse of that scheme. I mean, that was even part of my speech at CSOS now at the Indaba, and they quoted that. They said it's almost like a capital crime when levies are not paid. So luckily they are starting to understand that is the lifeblood of a scheme. It needs its levies. Otherwise, it causes the collapse of the scheme. Okay. Yeah, so I think we've answered quite a bit of answers. Durban courts, I can tell you, we would not go through the magistrates courts in Durban. I see Wendy asked a question about Durban court. So we would not go through the magistrates court in Durban because we are not getting orders to sell the property in execution. They would require Section 65 procedure, which is not required in our law. And that is one of the innovative things that we have done in the industry, is we've moved matters from the magistrates court to the High Court through DTB and Dilen Heerschop, and it's called process in aid. So it is a mechanism that we use where we jump matters, where you issue summons in the magistrates court, but then jump to the High Court in respect of your execution. But you need to know how to do process in aid if you want to be successful with process in aid. So yeah, I think those are the answers, Alex.
Yeah,
next?
I think we've answered most of it.
Lauren, can you move on to the next slide? Okay, so the solution, redefining legal collections. So what we have thought, I mean, we have as Stratafin, we've been in the industry now for 10 years or close on 10 years, and we do a lot of collections through various firms. One of the firms is DTB Attorneys, so there you've got your list. But we do a lot of collections, and we have learned a lot of lessons during this period of time in respect of collections. So we make sure that we have a proper panel of attorneys, we assess those attorneys, and we ensure that those attorneys are well versed in respect of collections and in respect of sectional title and community schemes law in general. And then we've negotiated fees in respect of all our collections. So we use the economies of scale in favor of bodies corporate. So it means that we can now agree with attorneys on a party and party scale. Most attorneys will not work on a party and party scale. We did see that people are saying that they paid from 0 to 30,000 Rand to attorneys. That is definitely not what is paid in the industry up to sale and execution. Your expense in respect of that collection will exceed 20,000 Rand. So that will mean that an attorney charges 10 Rand as a fee if his expense is 20. So we don't see that type of fees. Maybe this is in the respect of soft collections over periods of time that is then debited to the owner's account or so forth. But definitely, I mean, your legal expense in respect of services, advertising, and all those type of expenses that form part of that exceeds 20,000, was close on 20,000 Rand. So it will mean that attorneys charges about 10 in respect of the work they do. So we utilize the economies of scale, and we would pay attorneys on a party and party scale. So I think everybody understands what that means, and it means that we can now have a full recovery of that amount from the debtor once the amount is taxed. What we've also started now doing is funding for collections, so schemes that don't have money available for collections, to fund them to the tune of the party and party fee. So we would say we will fund you if it is a scale A to the tune of 35, scale B to the tune of 38 or 40,000, and so forth. So all the different scales have got different thresholds of funding, which is the party and party or very close to the party and party fee, which means that at the end of the day, the scheme will be able to recover all the money or almost all the money from the debtor. There might be a slight little amount that is payable out of the administrative budget, but in general, the scheme will recover all of that. The scheme will be liable over the period of collection for the repayment of that. So it also improves the cash flow in that instance. And we will also manage the collection through Imperium. And I'll quickly touch on Imperium as well, but it also gives you a very transparent process. So you can just jump to the next slide. Okay, so Imperium, we've built software that gives us real-time reporting, and we initially built this for Stratafin so that we know exactly where all our collections are with our panel attorneys. They utilize software that is specifically designed for our collections process and specifically written for that, with the reporting on top of that, where we then on a dashboard can see whatever is happening in a real-time basis in respect of those files. We sit with a collections dashboard that tells us exactly what step needs to take place, when it should take place, has it taken place, no it hasn't, why has it not taken place, and it gives you access to all your documentation. So if a summons was issued, it shows you your summons. The warrant of execution was issued and served, it shows you the warrant, it shows you the return of service from the sheriff and so forth. So all of those documents are available. It also is predictive. It tells you what the next step should be and when that step should take place. So it takes into consideration the time periods by courts, and it says to us, for appearance to defend, the person has 10 days. So we expect an appearance within this period of time. Only after that can we do the next step. This is how long it will take. For example, it's Durban Magistrates Court. In Durban Magistrates Court, we wait 4 months for a default judgment. In Randburg, we may wait 60 days for a default judgment. So if it's in Randburg, it will tell us we expect it to be this date. If it's in Durban, we expect it to be this date. So there's a predictive element to the software that tells us when these things should happen. There's a portal for community schemes where they then can log in and they can see their collections. So this is starting to run now. We've developed a portal, so we're at the last stages of that, and then it will be open for schemes to actually see their collection taking place and what will happen. In terms of our agreement, then we will have turnaround times with the attorneys in respect of these matters, and we will ensure strict compliance with those milestones and make sure that those things happen. We're constantly busy with ways to try and improve the collection process. I mentioned processing aid. I think that's one of the things that Stratafin brought into the collections process. We had a problem with that, and the court did not grant our order for processing aid. We wanted to take it on appeal and eventually decided to change the strategy how to apply for processing aid. So processing aid is where you ask the High Court to aid the Magistrates Court because we do not get a proper order in the Magistrates Court. So for example, the one in Durban that we discussed earlier, where we would require a sale and execution of the property, but the court says, no, we will allow the debtor to pay the debt off. So you will then be able to apply to the High Court in processing aid to assist to get the property sold. So those are one of the things that we've introduced in the collection process, and that we are running with the attorneys that are on our panel. This causes that you don't have a burden on your administrative budget, because at the end of the day, if you've got your party and party fee, you can recover that at the end of the day. Although there might be a cash flow implication when you initially pay your collection, at the end of the day, you will recover all of that from the debtor, and the scheme will be in the same position that the scheme was in the act, in the prior act, where all the fees could be recovered from the debtor. So at the end of the day, the paying owners will not be liable for the payment of the legal fees for the collection of arrear levies. Lauren, you can move on. Any questions? Okay, so we're at the end. So we've gone through the whole thing. I don't know. I see Dilen. Last time I checked, there were 7 questions. We're on 50 now. So maybe if you want to have a look at a couple of more of those questions and answer a couple of them.
Yeah. So the first one: will we be able to receive a copy of the slideshow/recording? From what I understand from Stratafin's site, they've got a YouTube channel, so all of you guys can go and listen to the YouTube presentation and also get the presentation. I see Eleanor also says, once notice has been given that the bank is foreclosing on a property, which takes months to execute. I agree with you, Eleanor. Can the body corporate still go against the owner for outstanding levies? As the BC is aware that there's a large outstanding amount due to the bank, the owner is not paying levies, nor the bank yet has a tenant in the unit. Remember, regardless of what the bank is doing, that does not preclude the body corporate from doing anything. I've seen instances, and the problem that the banks have is that they've got different panels. So they've got one panel of attorneys that will deal with a matter until default judgment. Then that matter has to pass to a new panel. Now, 6 months down the line, the instruction is given to the new panel attorneys, which is the execution attorneys, to get the order now to have this property sold in execution. Then again, the file is closed. Then again, it goes back to the bank. The bank has to instruct other attorneys to deal with the auction of the thing. And the problem is, we must understand that the bank is a huge financial corporation that probably makes decisions based on where they want their cash flow to be. So ultimately, maybe they realize they could get a bit more interest on this specific property, so they don't want to execute as of yet. So that makes it frustrating dealing with the banks. We can never say, you know what, within 6 months of the bank giving notice, we know they'll sell, because we don't really know. I mean, some of these things drag along as long as the banks decide for it to go, and that's a problem. But ultimately, it doesn't preclude the body corporate from instituting their own legal action. So you can run a legal action concurrently with the banks and collect the indebtedness and also proceed with sale and execution. I mean, we see it a lot where the banks are far in front of us if you look at the legal progress where they are at, but we still beat them to the sale. So that's basically the gist of it. Banks, it's going to take too long. And the fear that I have is that there's a situation where all of this value now exceeds the property amount. And no bank, to my mind, is going to go to court saying, we want our own bond reduced so that we can pay everything. So then we're sitting in a situation where there may be perpetual indebtedness. So it is a problem, but the body corporate, in any event, can institute legal action regardless of what the banks are doing. All right. And
One other question is the attachment of rental. So that is a very good strategy to follow. So that can be done through CSOS and through the court. So the CSOS mechanism in this regard, I would think, is easier than the court process. One can apply for an order for the attachment of that rental, but then the scheme needs to know who the tenant is, what the rental contract is, and what the rental amount is. So it's important for schemes to have that information at hand, and they can then apply for an order for the payment of that rental to the scheme. And what is left over can then be paid to the owner. So if the owner is in arrears, then the full amount can be utilized in respect of the payment of the indebtedness. And once the indebtedness has been paid, then the owner can start receiving money from that rental again. So that is a very good strategy to follow by schemes, and should be done as quick as possible to make sure that they get the money as quick as possible in respect of that as well.
Yeah, and then the last question, and I'll leave it to the big fish in the pond, Willie. How do we get in touch to contribute to the development of the industry? I'd like a more personal engagement.
So yeah, so we're always open to speak to people. I think NAMA is always open to speak to people. CSOS is open to speak to people. So if one wants to be part of the industry and you want to contribute and you've got expertise to give, I think that all the role players in the industry are always happy to have people that come forward and say, this is my suggestion, and have a talk about that. We've gone through the same process where we in the industry have also started speaking to all the role players, and eventually we are a role player ourselves as well. So it's a question of putting yourself out there and making sure that you take part in what the industry provides. I think that's the way to do it. All right.
Yeah, thank you everyone.
Dilen,
Yes.
Before you run away, I see that we've lost quite a few people, but I think we've had a discussion before, you and I, about that one little aspect, letters of demand, and maybe that's a good time to maybe throw that out there as well, in respect of letters of demand by schemes.
Oh yeah, so to my mind, and this is what I'm seeing, a lot of attorneys are charging a fee for a letter of demand, which is a pro forma letter that anyone can type. So I'm seeing thousands of rands, and I mean, I'm not even overestimating this, thousands of rand being applied towards letters of demand. These letters of demand could be sent by a managing agent, could be sent by trustees. So that might be a helpful method within which one can actually send letters of demand without incurring that cost. I mean, then ultimately we will then hand over to the attorneys after that. My suggestion would just be that when we decide that we are going to start doing letters of demand in-house as a managing agency or as a community scheme itself, please just consider prescribed management rule 25 and make sure that we adhere to certain things. We need to understand that the notice must provide them 14 days to repay. We need to understand that we need to inform them as an owner, you've got an obligation to pay. We need to inform them about the amount that is indebted. So just go and have a look at prescribed management rule 25 in general and make sure that we actually comply with that.
Can I put you on the spot, and can I ask, will DTB give us a pro forma letter of demand as a free resource that we will make available with this webinar, that we will send out to all the participants, that they can use as a pro forma, and where they need to now fill in just the details?
Yeah, I think that's a great idea. So we can do it. Ultimately, let's deal with it. Let's help the industry. I mean, ultimately, I think all of us has got the same goal. We want that tenant or that owner who's not paying to pay, and anything that we can do to save costs, we need. I mean, unfortunately, we're in a place in South Africa, and I would say in the world, where financially we're struggling, and ultimately we need to save or cut costs as far as we can. So most definitely I will. But from my side, Willie, thank you very much. I always appreciate being part of these types of webinars, seminars, and everything, and the effort that you guys do to educate the industry. And thank you to the attendees as well. I think it's really important, these guys attending these types of things. They are the cream of the crop in the industry, and they're actually taking the time to better themselves. So yeah, thank you for listening to my boring voice for an extensive period of time.
Thank you, Dilen. And also from our side at Stratafin, we thank you all for being part of this. One last answer: you can put an acceleration clause into your levies, so the trustees, when they resolve how levies are paid, can say that the levies is payable on the first day of the first month, in respect of the new levies that needs to be paid. And we will allow the payment of it in 12 installments, but if one installment is not paid on the due date, the full amount will be recoverable. So you can make that part of your resolution. You can then send that out, and that will then assist, once there is a failure to pay that levy or the second levy, that the full amount can be issued summons for, and you don't have to issue 10 summonses or 12 summonses every month for the next year, and for a higher legal cost. So definitely so. Thanks for all the questions. Hope we gave you some answers, and hope we can assist. And where there is any assistance required, phone Stratafin 011 051 8555, and we can definitely be of assistance to you.
Thank you, Willie. And just to finish on that, so we will print out all the questions with answers and send that out to everyone that are registered for the webinar next week.
Thank you.
Lovely.
Appreciate. Thank you. Thank you. Bye-bye.